times directly. What you can do is throw them into the general process.
Thank you,
We think
Counsel.
that's the minimum that should be done here.
Thank you, Counsel. We've been talking about connection between the regulation of TikTok and the burden on expressive conduct. And your basic position is that interfering with the ownership of TikTok constitutes a direct regulation of the expressive conduct of other people. What is your best example in our precedent of a situation where a regulation of corporate structure or something else has been treated as a direct regulation of expressive conduct?
The regulation of a corporate structure as Your Honor, I don't have a case at my fingertips. I can consult.
Well, I don't have one at my fingertips or any other
rebuttal, but I think it's quite clear, though, that if you're saying to a company, you have to stop talking unless somebody else does something, and that's imposed by the force of law, it directly affects that company's speech.
Well, again, I don't know if it's directly affecting the company's speech or the speech of third parties, and I'm not sure what, where your emphasis is. But again, I'm not sure there's another case where we've said that regulating a company others' expression should be treated as direct imposition on their speech in terms of the standard of review, for example, when it's based on derivative regulation of corporate structure of somebody else.
Well, Your Honor, I think that I would concede that this is a pretty unprecedented case. I'm not aware of any time in American history where the Congress has tried to shut down a major speech platform. But I think that if a law imposes a direct regulation on a third party, that in turn results in shutting down somebody else's speech, and they do it for content-based, viewpoint-based reasons, and in particular on this record, because the speaker that is ultimately being shut down, they don't like the speech of that particular platform. That's a real problem.
So it may be a real problem or may not, but I just am wondering if there's any precedent where we have that same connection and that it affects the standard of review, for example. You would treat it as a direct restriction on expression. Even the only thing the law does is say, in this case, somebody other than the Chinese government has to own.
So we don't have any direct precedent along the lines that you're citing, but we do have precedents. We have cases like ACARA, and what ACARA says is if the law is totally speech neutral, then that's one thing. We have cases like O'Brien, which say if the law doesn't care about speech but happens to draw in speech, that's another thing. Both of those cases make clear, however, is that when the law is concerned with the content of the speech, when the justification is based on the content of the speech, that's cases like Reed 2, then you do trigger strict scrutiny.
So then I think your argument comes down to, is this direct concern with speech, or is it concerned with the potential for Chinese interference with the level of interference indirectly? In other words, they're not coming back. The Chinese government, TikTok, doesn't care what the people are saying on TikTok. That's not the concern. The concern is that they are regulating a particular channel of communication. And I just wonder if there's any precedent for that type of thing. They're not saying we're going to restrict this content and that content, but not this. They're just saying we're going to be in a position where we can control what happens, whether it's based on expression, whether it's based on anything else.
So, Your Honor, I disagree, and I think if you take a step back and look at this record, I think it is quite clear that it is focused on both current and potential future content on TikTok Incorporated. Here you don't have just an act that is based on speakers and speech. It's triggered by speech. It's focused on a single speaker, TikTok Incorporated.
Justice Thomas?